official welcome. It's important to note that this collaborative effort have been coming on for a few years. And the important issue for us is to ensure that we advance women's rights, but in particular, beyond COVID. We have seen over the past 2 years that there has been many challenges. And we have also seen 2 particular cases that the Women's Legal Center has done that has come through and which impacts significantly on testate and intestate succession. The center supported the challenge relating to the intestate succession on the basis that it unfairly discriminated against opposite sex life partners. And I think it's important that we discuss these issues this year. As we note, this year's Nationals World Week will be taking place from the 12th to the 20th of September, and legal practitioners will be called upon to provide free legal advice and free drafting of wills. So in partnership with all of these organizations, I'm again welcoming you. Our first speaker up will be Eunice Masepa from the Law Society of South Africa. I'm welcoming her. And let me just give you a background of Eunice. Besides the fact that she is a practicing attorney, she's the vice president of the LSSA. She's an attorney and director of Masepa Attorneys, and she was admitted in 2015, and she has been a member of the LSSA's House of Constituents since 2019, and she also has been a member of the National Association of Democratic Lawyers, EXCO, and is currently the Deputy Treasurer. She has been a board member of the Legal Provident Fund since 2020. And Eunice, I welcome you, where she will be speaking to us about the importance of World's Day, why it's important to have collaborative work and partnerships like this, and how we can advance the rights of vulnerable communities and women in particular. Thank you very much, Eunice. Over to you.
Thank you so much, Comrade Samai, for that warm welcome and a beautiful introduction. Greetings to all panelists, greetings to all esteemed guests and all our attendees. As I've already been introduced, my name is Eunice Masepa from the Law Society of South Africa, and I'll just be addressing you on the importance of Wills Week. Now, to give you a brief history as to where Wills Week emanates from, it was established when, and it went national in September 2008, when the Law Society of South Africa obtained a buy-in from all the constituent members. But previously, Wills Week was an initiative of the former Law Society of the Northern Provinces. And after that, after obtaining the buy-in from the constituent members, it then went national. And now to speak on the significance of Wills Week, it is an initiative to assist members of the public who would not normally make use of the services of an attorney, or who may hesitate to consult an attorney for fear of possible fees resulting from a consultation with an attorney. There is this thing that, to consult an attorney or to have a face-to-face with an attorney will cost you an arm and a leg. But with this initiative from the LSSA is to promote that access to justice to the less privileged. Now, the aim of the campaign also is to make attorney services better known to the public, and also to improve the image of the profession, and to create an environment which is friendly of client care from the attorney profession. And, I strongly believe that this initiative by the LSSA provides attorneys and also provides law firms an opportunity to give back to South African citizens, to the less privileged, to the vulnerable, and it's also a positive step towards the advancement of a right to access to justice. And, although we don't want to think about it, but the pandemic has reminded us all of of our mortality. And as unpleasant as it may be, it is important, for us to consider what will happen in the event that we die and how our loved ones will be taken care of. And just to emphasize further, this initiative is also an encouragement from the LSSA and the legal profession for South Africans to take care of their own, even in death. Without going into detail, because there's a speaker who will be speaking on the importance of having a will, but without going into detail, one of the importance is that you have the opportunity to appoint a legal guardian in the event that you have minor children. I believe this is a great privilege because you avoid an instance where your minor child is tossed around within the family or, is being taken care of by a person you would not have preferred. So, so it is very important to get your will drafted. And I believe the speaker who will be speaking on this topic will go into detail. In conclusion, the Law Society of South Africa and with all the stakeholders, and going back to the Law Society of South Africa as a members' interest organization and a public interest organization, with this initiative, it's actioning its mission to safeguard the rule of law via efficient and fair administration of justice. I just want to say thank you to the organizers of this webinar. Thank you, Program Director Siham, for the opportunity to conscientize our people on the importance of having a will and the significance of Wills Week. Thank you, Comrade Siham.
Thank you, Comrade Eunice. The person that I've been coordinating this and that have been pulling us all together, and I have been, which is from the Department of Justice, and she has been holding us, and I think that it's only appropriate that I call on her, which is Penny Roberts, from the Office of the Chief Master. Please forgive me, Penny. You're always so silently behind the scenes. And I think it's important. It's a very important department. And I'm just going to call on you to be able to give a few words. Penny has joined the Department of Justice in 2004, which started as an estate controller. And in 2008, Penny moved to the department's regional office in the Western Cape. And that is where I met her, where she worked as the legal administration office. And then in 2012, Penny Roberts relocated to Johannesburg and joined the Office of the Master in South Gauteng. And from the 1st of November 2020, Ms. Roberts was appointed as the Master in Pretoria. So congratulations, Penny, for that also, a position which she currently holds. And Ms. Roberts always had a passion about matters which affects the vulnerable members of a society. And I call on you just to be able to say a few words. Thank you.
Thank you, Program Director, and good afternoon, ladies and gentlemen. Thank you for the opportunity. Yes, I worked in the regional office, so I remember Ms. Yam very well. And welcome to the session for the Wills Week National Campaign. So the Office of the Chief Master has requested me to provide the opening remarks for this session. So as we have indicated previously, every year since 2017, for 1 week in the month of September, the Department of Justice and Constitutional Development partners with the legal fraternity, for example, Legal Aid South Africa, the Law Society, SAULA, South African Women Lawyers Association, and other legal fraternities in order to educate members of the public on the importance of having a will in place as part of the National Wills Week campaign by having wills drafted free of charge. So this year is no different, as there are other were a number of activities that took place during this important week at various places and areas in our country. As we reflect, I think we should actually, continue with regards to community outreach programs, especially on issues that affect women. We have found that in our space from the Master's Office, a lot of women actually are receiving the brunt when it comes to the administration of the state. So as we continue to embark them on public education, we should take note of the fact that once a will is drafted, for example, it is the responsibility of the testator to keep the original will in a safe place, and also to inform their loved ones as to where their will is kept, so that the testator, should they pass on, they can be able to actually their loved ones can be able to trace the will, the original will, because the will only comes to the Master's Office when a person passes on. So another important factor that we should also take into account is that members of the public must actually amend their wills, especially when their circumstances have changed in their lives. For example, they get married, they have more children, then they get divorced. In terms of the Wills Act, it's very important to know that if you don't amend your will within 3 months of the divorce, your ex-spouse actually will be deemed to have predeceased you. So at least you are protected in that regard. So after 3 months, if you still haven't amended your will, your ex-spouse might actually still inherit from your estate. So you need to take that into consideration. So we need to, to take into account that our wills must reflect our current situations as we go along. And also the will must also reflect on how our assets are going to be distributed when we die. Furthermore, awareness should be made with regards to the marital regimes that the women actually find themselves to be in, because at the end of the day, the type of marriage regime that you have entered into can have an impact on how your estate will be distributed at the end of the day. So I urge women to be empowered in this regard. And lastly, and most importantly, proper estate planning includes the drafting of wills, which also complements an estate plan whereby it also covers the liabilities. But because the reality of the matter is that when you die, your debts will not also vanish. Unfortunately, your creditors can also have a claim against your estate for the outstanding payments that they are owed. So we hope that members of the public will make use of this opportunity of having their wills drafted free of charge during this week. And we also request that they should spread their news regarding this National Wills Week campaign. I would also like to give a special word of thanks to the legal fraternity for their continued support and contribution in making this campaign a reality by giving their precious time in plowing back to the community through their participation. And with these words, I thank you.
Thank you very much, Penny. I'm now going to hand over as we go into, the issues around what is a will, etc., and some of the mandates of Legal Aid South Africa. So I'm going to call on Ainunisa Hendricks, and she is currently from Legal Aid South Africa. Ainunisa, I know that you are quite excited to do your presentation, but I think I must first inform people who you are. It's important to know. And so let me just go down to my notes. So Ainunisa currently holds the position of National Legal Manager Civil at Legal Aid South Africa. She has a long career with Legal Aid South Africa and have always worked towards empowering citizens about their rights and ensure that they have legal representation. Ainunisa is passionate about ensuring citizens know their options in respect of wills and what will happen to estates once they die, and to ensure that they have the agency in respect of their assets. In addition, she's especially passionate to ensure that there is a gender equality in the law of succession and that women know what they're entitled to. What she tried to live by, and I think is very important, be the change that you see. Welcome again, Ainunisa. We look forward to your presentation, and hopefully there will be many questions. Just quickly, I just want to inform those that are online, there is a chat box. And secondly, you will have an opportunity after the presentations to put up your hand and to ask the panelists questions. Thank you. Ainunisa, over to you. Ainunisa, are you talking? You are on mute.
Sorry, thank you, everyone. I was saying that thank you, Shyam, for the introduction. Today, I will be talking to you about why we need a will and how do we do a will. And, you know, what I want us to think about is where we are in our lives today to start the conversation. So if you are in the middle of that circle that you see in the screen, on this
Ainunisa, are you on mute again? Ainunisa?
Hi, Chairperson. I think we lost her.
Okay,
think
yes,
we
it's
lost
the
Ms.
load
Amos.
shedding. Can I ask Ms. Jonkers if she can do her presentation? And can I just introduce you? Ms. Jonkers, are you ready for us?
Yes, you may. Thank you.
Okay. Just Ms. Jonkers is an admitted attorney and have over 19 years postgraduate experience, of which 9 years was within the private sector, and the experience specifically relates to the Master of the High Court. Ms. Jonkers is also currently the Deputy Master of the Eastern Cape High Court, and she's responsible for overseeing the deceased estates trusts. And Ms. Jonkers possesses an LLB degree as well as a certificate in deceased estates administration. Welcome, Ms. Jonkers. Over to you. Thank you.
Yes. Thank you, Ms. Samai. Yes, as the introduction was made, my name is Simone Jonkers, Deputy Master of the High Court in Gqeberha, previously Port Elizabeth, and I'm responsible for the sections of deceased estates, trust, insolvency, and curatorship. But for purposes of today, I will be focusing on the administration of estates part. Ms. Hendricks was now supposed to have started the importance of a will part, but because she now was cut off, I had to fill in now, and I wanted actually to follow on her because the administration process starts once the person has passed away. So you do need to have a will, and if you do not have a will, unfortunately, the law will determine how your assets will be distributed. But let me start off by saying that as soon as a person passes away and you have assets, the estate needs to be reported to the Master of the High Court. Now we have about 15 offices around the country and about 402 service points. Those are magistrates' courts that are linked to the Master of the High Court, where estates can also be registered. So once a person passes away and the person has assets, one of the family members or any interested party may come to the Master's office to report the estate of the deceased. Now, the process starts once the application is made at the Master of the High Court, and it is only our office or one of our service points that can assist with the administration of a deceased estate. Now, our service points have a limit of 250,000 rands. If an estate value is up to 250,000 rand, you can register such an estate at the Magistrates Court, which is linked to the Master's office. But you can only do it if there is no will. Once there's a will, it must be reported to the Master of the High Court because a decision must be made on the validity of that will. Now, the requirements to report an estate, once you report it to the Master, there's a couple of documents that you need to complete, but because of time constraints, it is a bit difficult to list these things, or would have presented it on a presentation to you all, but you need to report it, and one of our help desk operators will be able to provide you with the necessary documents to report the estate. Now, once you report the estate, one of the first questions we will ask is, did the deceased have a will or not? From that, we will determine who needs to be appointed as executor. Because if you have a will, the will will determine who will be the executor. And if there's no will, the law determines who's going to be the beneficiaries. And from that, we receive nominations to appoint an executor, which we call an executor dative. So once the executor is appointed, the executor needs to start the process of collecting assets that the deceased had and distributing it in terms of what the will said or what the Interstate Succession Act said. Now, there's basically two processes that is involved in the administration of a deceased estate. It is the Section 18.3 estate, and then you get the estate which is administered in terms of a letters of executorship, which is in terms of Section 13 and 14 of the Administration of Estates Act. Now, once an estate value is 250,000 and below, a letters of authority will be issued. Now, once a letter of authority is issued, the client gets the letter of authority, or the master's representative. They can go outside, collect the assets, distribute it in terms of what the will was saying or in terms of what the Interstate Succession Act said. Now, we normally determine from a next of kin affidavit who the beneficiaries will be in terms of the Interstate Succession Act, and the master's representative needs to distribute the asset in terms of who the beneficiaries are on that next of kin affidavit. The other process that is in terms of the letters of executorship, it's a more intricate and complicated process for the normal person outside, or the lay person that does not have the necessary skill or knowledge to administer such an estate. Now, the letters of executorship is issued once the estate is above 250,000 rand, which means there is going to be advertisements that must be placed in a newspaper in the area where the deceased stayed. I must also state that an estate must be reported in the area where the deceased resided 12 months prior to his passing. So if you stayed in Johannesburg, you need to report it at the Office of Johannesburg Master. If you stay in another area and you want to do it at Johannesburg Master, you'll have to ask permission from the one office and a waiver of jurisdiction will be requested. So it is possible if you stay in one area to report it in another area, but with the permission of the office who had jurisdiction originally. So if the process starts, the executor receives the letters of executorship. He has 6 months to lodge a liquidation and distribution account with the master. But while the process is running, the first advertisement that is placed in the newspaper is to call on all debtors and creditors to say that they have a claim against the estate, or vice versa, whoever the deceased owed or who owes the deceased must lodge the claims with the relevant executor. And once that has been received by the executor will draft a liquidation and distribution account, which is submitted to the master. The master examines the account, and once the master is happy with the account, a query sheet is issued, and then the executor may then proceed to advertise that account if there are no amendments to the account or no issues with the account. And once that account is advertised, the account will call on all interested parties who might have an objection to the account to lodge his objection with the master or with the executor. And once that objection is lodged, a decision will have to be made on that objection, and then the process will proceed from there onwards. If the account is lain free of objections, the executor may proceed to distribute the estate in terms of either the will or the Intestate Succession Act, whichever is applicable. And from there onwards, there's small minor things that the executor still needs to finalize before a final clearance certificate can be received, for instance, from SARS, and also a filing slip from the master's office. So the fees involved in the administration of an estate is, if the estate is above 250,000, the executor's fee on that estate would be 3.5%. If it is that the estate is below 250,000 rand and you receive the letters of authority, there will be no cost involved, because it is a process that does not require the services, for instance, of an attorney, trust company, auditor, or accountant. And if it is above, it's the 3.5% maximum fee. You can negotiate the fee to be lesser than the 3.5, but the maximum is 3.5. These master's fees applicable, minimum 600 Rand, maximum 7,000, depending on the value of your estate. There's advertisement cost. There is estate bank details charges. So there is a few costs involved which people should be aware of, because you find that, it's Wills Week, wills are free, but sometimes the public would assume that the process at the end would also be free. But there's cost involved if your estate is above 250,000. There's transfer of properties fees involved. So it is not as easy as it sounds. It is an intricate process. If there's objections, it might take longer, but generally the process it's either in terms of Section 18.3 or it would be in terms of letters of executorship. As far as the executorship is concerned, we would normally require that a qualified person assist, because if a normal lay person assists with the administration or is involved in the administration, it might delay the process unnecessarily and it might be detrimental to the beneficiaries. But if a person has been exempted from security in a will, they do not need to submit security. So we would then appoint that person. So I think that would be my story. If there's any questions, you are welcome to ask in the chat box and I will answer all the questions later on. Thank you, Siam.
Thank you very much, Simone. That was quite, a lot of important information. And if there are any challenges, maybe Simone, if there are any questions, we will be able to put that to the particular panel. I don't know, Hainunisa, are you ready for us? I don't know in terms of your load shedding, otherwise I will hand over to the last speaker.
Hi, Shyam. Thank you. I'm back and I'm ready to proceed. If you can hear me.
Yes, I can.
Okay. So apologies, everyone. We have load shedding on this side. I had load shedding, but as we all know, by now we roll with the punches and we just go on. I see that I'm not able to share my screen now, so I will just be talking to the presentation. So I started saying that when we think about why we need a will, we need to consider the people that we have in our lives, or where we are in our lives. So if you put yourself in the center, you think of the people around you that you are responsible for, that you want to take care of, that you would want to be taken care of when you are no longer there. So those people would include your partner, your wife, your husband, your child, your grandparents, your parents, your sister, your brother, an uncle, perhaps, even a nephew or a niece. You know, your brother's children is your children. That is how we live our lives in South Africa. So, or a close friend even that you are taking care of now and that you want to make sure are taken care of when you are no longer there. So these are the considerations, these are the people that we must be thinking of and that are in our lives when we think about what will happen when I'm no longer there. So I want to explain through an example what will happen if you pass away and you do not have a will. So then the law of intestate succession comes in, and that is how your estate will play out. So when in terms of the law of intestate succession, it says that the people that will inherit the assets of the deceased, firstly, in line will be the spouse or spouses. If there are no spouses, then it will be the children, the biological children or adopted children of the deceased. If both the spouse and the children are still alive and have survived the deceased, then those are the people, both groups, that will inherit. Now think of what I said in terms of the people in your life at the moment. You have a father, you have a mother, you have grandmother that you are currently taking care of. But if you die without a will, as I've said, the first line of people that will inherit will be your spouse and your biological children and adopted children. So in terms of intestate succession, if those groups are still alive, your mother and your father and your grandmother does not stand in line to inherit. The estate will go to those people that have survived you, meaning the spouse and the biological children and adopted children. So in the event that you want to make sure that your mother is taken care of, your father is taken care of, if your grandmother is taken care of, it is important for you to make a will so that you can then state what you want to have happen. You can say what assets must go to your grandmother. You know, you can say what assets must go to your mother, because in the absence of that will, your assets will automatically, in terms of intestate succession, go to your surviving spouse and your surviving children. And it will not automatically go to your grandmother and grandfather. So you need to make sure that if you want to take care of them or you want to make provision for them, then you need to make sure that you make a will. And in this will, you can then state what you want to have happen. As Eunice has said, in this will, you can also then state what must happen to your children. For example, if there's no one, you can state in your will that who will then be the person that you trust to be the guardian of the children. If you want to create something like a trust for your child, then you can use a will to do so, where you create a trust for your children and you determine how the assets in terms of the trust must be handled so that it's dealt with to the benefit of your children. So what I want you to take out from this discussion is that if you don't make provision for people who automatically stand in line first after you pass away, then there is no provision for them in terms of your assets. And the way you make provision for them is by using a will, is by making a will so that you can be sure that when you and have the assurance, reassurance that when you are no longer there, your grandmother will be taken care of because you left X, Y, and Z for your grandmother. And so now we come to the requirements of a will. Now that we know, the importance of a will and why we need to do a will, we come to the requirements of a will. So a will is a document you do in writing. So I know that our law and our circumstances in life has developed to a point where many things happens electronically. And yes, the court have, in some instances, maybe recognized a will that has not been in writing and then has been electronically. But that requires for you to go to a court, to have a court say that this is a valid will. When you are in charge now and you have the opportunity now to do it properly and do the will in writing, because that is what the law now says, and the master implements what the law says. So when you go to the master and you say that this WhatsApp message I want to have was the final will, a testament of my loved one that passed away, the master will say to you that the law requires X, Y, and Z, and the law says it must be in writing. So it is then incumbent on you to go to a court to show that it was a valid will. So we want to avoid that situation. We want to avoid having to litigate over things that could have been avoided. And so when you have the time now, make sure that the will is valid, make sure that it is in writing, right? Besides the will having to be in writing, the testator must sign each page and sign the will at the end of the document. So if the will has 4 pages, it means that the testator must sign the first 3 pages and it must sign at the end of the will on the 4th page. The Wills Act also determined for the will to be valid, there must be witnesses, and these witnesses must be competent witnesses. It says that a competent witness is a person that is older than 14 years and that is not incompetent to testify in court. So when you choose witnesses, make sure that they are older than 14 years and that they are people that would be competent to testify in court. There must be 2 or more of these competent witnesses when you do the will. So when you do the will, this testator, you as the testator must sign in the presence of these witnesses, or at least acknowledge your signature on this document that you say is your will in the presence of the witnesses. The witnesses must sign in the presence of the testator. Now, signs in terms of the Wills Act, sign is not only when you write out your name. Sign can also be, you can also make a mark as a testator on the will, and you can also ask somebody else to sign the will if you are not able to sign the will. But then the Wills Act says that where you use these other methods to sign your will, you need to use a commission of oaths to certify that the identity of the testator is this person that is either making a mark or using someone else to sign the will, that this mark that is on the will is indeed that of the testator, and that it was made in front of the commissioner. So the commissioner acknowledges that this document was made in front of me, and the commissioner must acknowledge or certify that the testator knows the contents of this will, meaning that the testator knows what it says here in the will. So these are the requirements of a valid will. If you make any amendments, remember what Penny said, where your life changes, things happen in your life, you might need to amend your will and change your will. So where you make any amendments to your will, these requirements remain the requirements to make even that amendment valid. So remember that if you have a will and you want to amend something, you cannot just do it on a little piece of paper and not follow any of the requirements that I've just mentioned. So the requirements for your amendment is the same. You must sign all pages. There must be witnesses that are competent, and where you are not able to sign, where you cannot read and write, then there must be a commission of oaths that certifies that this is your will, that you know what it says, and that you made the mark or ask somebody else to sign for you. You know, Wills Week, as everybody has said, that Wills Week is in this week now, and we've always worked together in Wills Week and the legal profession has done wills for clients in Wills Week free of charge. But at the bottom, but Legal Aid South Africa, sorry, I forgot that you are not able to see my screen, but Legal Aid South Africa has got an advice line, a legal aid advice line. You can always call our advice line and ask advice about any aspect. You can ask advice about intestate succession, about wills, about testate succession, about what happens after I died, about the administration process, as Shimon has spoken about. You can call them anytime, not only this week, you can call them anytime throughout the year for advice about wills or any other legal advice that you need. The legal aid advice line number is 0800 110 110. I will put it later in the chat, but I will just repeat it again. 0800 110 110. We also have an SMS number where you can a cell phone number where you can send an SMS to, and we will call you back. Because sometimes we listen to things and later on we mull through what was said, and then we might have questions about what was said. And then you can call this number and they will be able to guide you through any legal advice that you need. So I hope I've explained a little bit about why it is important for us to have a will, and to make provision for our families or for those people that we leave behind and that we would want to take care of, or we would want to be sure are taken care of when we are no longer there. Thank you.
Thank you, Ananisa. I'm just going to now call on the next speaker. There's two more speakers. And then I'll open it up for questions. And then I'm going to call on Nomisa Ngogo, which is from the South African Women Lawyers Association. She is an attorney and she's a conveyancer based in East London. She holds a B.Juris and LLB degree from the University of Transkei and of University of Natal. And she has been practicing for her own account since 2004. Administration of estates comprise a significant part of her practice, and her firm regularly participates in Wills Week. She has been also an instructor on wills estates in the LSSA for almost a decade, and she's passionate about human rights, access to justice, and particularly the advancements of the protection of women's rights. She currently serves on the NEC of both the South African Women Lawyers as well as Nadal. Thank you. Thank you, Nomisa. I'm going to hand over to you to address the listeners. Thanks. You mute.
Okay. Thank you, Siham, for the kind introduction, and good afternoon to the participants as well as the fellow panelists. My topic for today is empowering women to bridge gender disparity. I will be speaking based on the experiences, lived experiences of women in particular when it comes to deceased estates. The first thing that I will mention is that for women, it's important that they understand that there is no such thing as a separation in law. If you have not divorced, the law says you are married. So we find it that people, because they've been separated for decades, they think they're no longer married, and we find that people they think that they no longer have a spouse because they were separated. And therefore, it's very important that if you are married either by customary law or any other marital regime, that you must make sure that you divorce. Because if you're not divorced, you must understand that if you're married in common property, what you bequeath in your will is only your half share of the estate, not the entire estate. That is important. Again, as I say, the marital regime is important that you understand. If you're married in common of property, you can only dispose or deal with your half share. And if you are married out of common of property and there is a will by your spouse and you are not benefited therefrom, you probably will only be able to claim maintenance as a surviving spouse. You have no claim automatically as a surviving spouse. Our law is developing in that regard, but that's how it is at the moment. The other problem that we find that women in particular face with is unregistered customary marriages, that after death, women have to fight to prove that they are indeed a spouse. And often there are feuds or family disputes as to whether there is the marriage or not. We know in our law, in terms of the Recognition of Customary Marriages Act, the fact that the marriage is not registered does not make it invalid, but often the proof of an unregistered customary marriage is a challenge. So our call is that if you're married in terms of customary law, try and have it registered during your lifetime. Your witnesses and your children in particular may not be able to prove it, or will have to bear a huge legal cost in trying to establish the marriage or the existence of the marriage, as it were. The other problem that women find in particular is in relation to children, especially if they were not married to the biological fathers of their children. And often they have to prove paternity. Sometimes it's easy, sometimes it's difficult. So my advice is, if you have children, make sure that you have the parent acknowledge paternity during their lifetime, either by having a maintenance agreement between the parties, or even at the maintenance court, and also make sure that you have proof that if they were paying for school fees or if you were applying for admission in schools, that the co-parent signs and acknowledges, so that it's easy to prove after death. It can be a problem, and it often is. But also just to understand that even if in the case there is a will, even if a child is not an heir in the will, that you can always claim for maintenance of the child, of the minor or dependent child of the deceased. That is your right. You can have it quantified, and it's a claim against the estate. Same thing with the surviving spouse, as I mentioned earlier on, that in terms of the Maintenance of Surviving Spouses Act, surviving spouse has a right to claim for maintenance if his or her means are not sufficient to maintain her after the deceased. It's important to know that our law is developing, and I think the one-year judgment goes a long way in the development of our law, and I think we will see our succession laws recognizing that, as in pension law, that dependence on the deceased is a significant factor. At the moment, it's either in terms of the will, or it's in terms of the Intestate Succession Act, is in terms of the marriage or blood relation. In relation to descendants and parents of the deceased where there are no children. The other important thing that I must mention, especially now that we're speaking about women, is that women often are not involved in the financial affairs of their homes or households, and that they don't know what decisions were made by the deceased during the lifetime. And I think it's related to patriarchy, that men are basically make this decision traditionally, and women go along, and that sometimes you find that you are married in common property, and suddenly on the death of the deceased, you find that there are these debts or claims against the estate which you were not aware of or not part of. So it's very important that women have this knowledge about how each spouse, in terms of the Matrimonial Property Act, cannot enter into certain contracts without the written consent of their spouse. And I think generally, in terms of empowering women, our call as the South African Women Lawyers Association is to make sure that this literacy about the rights of women, the rights of children, we need to use this platform and other platforms during the Wills Week to make sure that people have knowledge about their rights and they access justice, as the other speakers have said. And I think for me, those are the most common problems that are faced by women, that I feel that often they have to weave through and seek legal advice to get assistance after the death of their spouses or parents of their children. Thank you.
Thank you very much, Nomisa. I'm going to call on our final speaker, who is from the South African Revenue Services, which is Ms. Puti Rasimpi, will be speaking on the role of the South African Reserve Services in the administration of deceased estates. And are you ready for us? I just want to say that she's been working at SARS for the last 16 years, and she started by 2006 as a graduate in the estate division and later got employed permanently as an auditor dealing with the estate duty and cases. Currently, the estate specialist in the estate segment team. She has various certificates and qualifications, which includes a program in forensic and investigative audit. So thank you very much. Ms. Puti, I'm handing over to you.
Okay, thank you, Speaker. Thank you for the opportunity. Am I audible?
Yes, you are.
Oh, thank you very much for confirming that. And I greet all the others that have joined on this panel. Okay, today from SARS, South African Revenue Service, Disease Estates Department, it is just to give you the flow on what happens when we are dealing with a deceased case, what the appointed person needs to do. So the first thing is to make sure that the deceased person is registered, because we do get cases where you find that the deceased person is not registered for tax as a date of death. So the most important part is to ensure that the taxpayer was registered. The executor is able to do that. And even internally, when a case is being audited, we can also put the deceased person on register. The other important thing is that we can have a deceased estate where you find that there is tax liability post-death. The executor can also do the registration of the deceased estate. This is the second registration number or post-death number. Even internally, where we've discovered that actually there is post-death liability, we can do the registration internally. how to notify SARS of the deceased case. The executor can notify SARS by making an appointment at any SARS branch and submit the relevant supporting documents. The other way, you can submit the documents on our online system on our www.sars.gov.za. You can also submit the documents by sending an email. If you are a registered tax practitioner, you can send an email to pcc@sars.gov.za. And for all other taxpayers, this will be our executors or maybe family members, those that are not registered tax practitioners. You can use the contact us at sars.gov.za. The process flow to finalize the disease estate. This is after the appointed executor has contacted SARS. The first important part is that the letter of executorship that is issued by the master, once it is issued, the appointed executor must inform SARS. This can be done at any SARS office if it's going to be done manually. The documents required for the coding process include the copy of the death notice issued by the master's office or the death certificate as issued by the DHA, the copy of acceptance of trust as executor or the copy of the letter of executorship, certified ID copy of the deceased person and executor, copy of the undertaking and acceptance of the master's directions, or copy of the letter of authority in cases where the estate is less than 250,000. The copy of the inventory, copy of the last will and testament, the name, physical address, email address, and telephone number of the executor and his or her agent. In the case of an agent, a power of attorney and certified ID copy of the appointed person. If we are dealing with an agent, it means the person that is appointed by the master, referred to as the executor, is requesting assistance from another person. In this case, we can refer to the person as a tax practitioner because maybe the appointed executor does not know how to how to do the e-filing, how to submit the returns, so they can appoint an agent. A power of attorney is required. Copy of the signed final liquidation and distribution L&D accounts when they become available, if it's applicable. So this means that if we have got maybe 2 or more L&D accounts, all of these liquidation and distribution accounts must be submitted to SARS. The estate duty return, referred to as the Rev 267. Once the deceased person has been coded, all outstanding tax returns should be submitted up to the date of death. This applies to all tax types: income tax, VAT, PAYE, SDL, UIF, and for estate duty, if applicable. This process could be done via SARS online services or via the SARS digital channels available on the SARS website. As soon as the executor has finalized the L&D account, it should be submitted to SARS together with the Rev 267, which is the estate duty return. SARS will perform an audit for all the taxes pre and post death. If like now the executor has submitted the L&D account to the master, please ensure that you also forward another copy to SARS. As soon as all the tax liabilities have been paid in full, the deceased estate compliance letter, which is referred to as the DEC, is issued for all tax types, including estate duty, if estate duty was applicable for that estate case. The DEC letter must be submitted to the master's office for the executor to be discharged by the master. So this means that when SARS issues the DEC letter, it means that everything is final on our side. It means that you have paid all tax liabilities. And obviously, by the time that we issue the DEC, it means you have submitted the L&D account. It doesn't just end with the submission of tax returns. After submission of tax returns, the L&D account and the Rev 267, which is the estate duty return, they must all be submitted to SARS so that we can do a final audit on the case. And as soon as everything is paid in full, or if there was a refund, the refund has been released, that's when the DEC letter can be issued. The DEC letter can be issued to the executor, who will now submit it to the master's office. I believe that I have covered most of the important issues with regards to reporting of the estate cases to SARS, and I believe that I've covered almost all the important points with regards to the process flow internally. Thank you, Speaker.
Thank you very much for that. There is a question for you. How does one get a reference number from SARS to pay estate duty due to SARS? Tata SARS office is not able to help on this, and I've been trying for quite some time now. I'm not clear whether or not you'll be able to answer that.
Okay, the Tata office, is that a SARS office or is that the master?
It's a SARS, Tata
It's a
SARS.
SARS office. Okay, as I was starting, I mentioned that it is very important to ensure that the deceased person is the individual as a date of death. That is the individual that we are dealing with, meaning during their lifetime, if they were registered for tax, that is the tax number that they will use to make payment on e-filing for estate duty. Remember, for estate duty, there is no EFTs. You cannot go to the bank. You have to make payment via e-filing. So it is important to have the tax number of the deceased person. If the deceased person was not registered during their lifetime and after their death, estate duty is triggered, it means that the appointed executor will have to register the deceased person for tax so that the tax number can be allocated. Only after the tax number is allocated, that is when the executor will be able to pay estate duty via e-filing. So in this case, I don't know if maybe the individual was previously registered or not.
Thank you. I hope that answers you. It's an anonymous person. There's another question, and I think that this will be for the master or maybe possibly for Legal Aid South Africa. If a deceased died intestate and the descendant was not sharing their surname and the deceased was not mentioned on the descendant's certificate, will they be able to claim inheritance without the need to change the surname to that of the deceased?
Siam, from a master's point of view, we generally don't look at the surnames, we look at the blood relation. If the child is the natural child of the deceased, and I would accept that the person meant the descendant certificate, the birth certificate, if the parents' names are not reflected on, then we don't look at those things. We have the next of kin affidavit, which is completed, and if the child's name is reflected on that next of kin affidavit, irrespective of the surname, the child will be considered a descendant of the deceased, unless someone disputes it, and it can go for blood tests to determine whether the child is in fact the child of the deceased.
Okay, thank you very much. There has been a few questions on the chat, but I do think that it has been answered. There is a question, I think, by Kenosi, which is with regard to estates of less than 250,000, how are the creditors informed of the reported estate? And in cases of a family house, will the house need to be sold to settle the liabilities of the estate? I think that is also for the master.
Thank you, Siam. Yes, if an estate is less than 250,000, there is obviously no need to advertise the estate. But as soon as a person becomes aware that someone has passed away, a creditor or whoever, they must then determine from the master's office whether the estate has been reported. And if a master's representative has been appointed, we will refer the person to that master's representative. Or if their claim is lodged with the master, we will forward it on to the appointed person. There is also a website, a master's web portal, where people can determine whether an estate has been reported at the master's office, and you'll find it on the Department of Justice website, where you can just put in the ID number of the deceased, the area, or the master's office where you think the person might have stayed. But if you don't have those details, you can just put in the ID number and it will tell you whether the estate has been reported. With regards to the family house, if it will be dealt with as in any other case. If there's assets and there's creditors, it must be determined whether the estate is solvent or insolvent. And if it does come to that property needs to be sold to settle debts, then that would end up being the case. But it can also be that beneficiaries maybe want to retain the property and pay in the money to settle the creditors, and in that way be able to keep the family house.
Thank you. If there's any questions, the listeners will be able to raise their hand and ask questions to any of the panelists. Are there any questions? Let me just check on the chat. There isn't any more questions. Is somebody raised? Okay. Moa raised their hand. Yes, I acknowledge you. Can you unmute?
Hello. Hello.
Yes, we can hear you.
Oh, I'm asking when assets are discovered and they were not included, like what happens in that case? Like when someone is not honest and they discover that the deceased owned maybe assets and they are not included, like the list that has been submitted is not exhaustive.
The master or maybe Legal Aid South Africa wants to answer that.
I will answer. If family members do not disclose assets to the master, we unfortunately do rely on the family members to give us the correct information when they are reporting the estate. But if anyone is aware that assets are not disclosed, which is to the detriment of beneficiaries or creditors, they should then come to the master's office and report that estate, the assets that are being hidden or whatever the case is. We normally would then ask them to complete an inventory, which we will then forward to the nominated person for his remarks or comments. And then normally the process will be taken from there as to whether the person should be removed or whether there is an explanation as to why the asset is not being reflected. But generally we rely on the family to inform us as to whether there's any discrepancies with regard to the information, or any person that has an interest that wants to lodge an objection or claim or come and report some irregular activity from the executor side or the family side to the master in order for us to act on that.
Thank you. Are there any other questions? What happens when the parties are married out of community property with the exclusion of accrual where there are children? How is the estate dissolved when one of the spouses dies?
Okay, I think I can take that one, Siam. Remember, it depends on whether there is a will in place. So if there's a will saying that the surviving spouse is going to inherit everything to the exclusion of anyone else, then it's fine, it would be covered. But in the absence of the will, the law of interstate succession kicks in. So the surviving spouse will actually be entitled to what we call a child's share in terms of the Interstate Succession Act. He or she will be entitled to 250,000 rands of the value of the assets in the estate, or whatever is greater the amount. And then the children will then inherit the residue of what is left from that amount. So that would be in terms of the marriage out of community of property, because here there is no joint estate is just separate estates. So hence, women need to be empowered about these things. Thank you.
Thank you. Are there any other questions? I don't see any on the chat. It is being questioned at the end. If there's any questions for Legal Aid South Africa, Hainonisa placed the telephone number on the chat. Also for SARS, the telephone details is on the chat. I don't know if the details of the master is on the chat. I think also just, are there any other comments, final comments from any of the panelists? Any other?
So, Chairperson, we have two hands on attendees.
Okay. Yes, I've noted. Can we have the persons? Unmute.
Yes, yes, Matisa, you can go ahead, Matisa Luhodi.
Yes. What is the basis for the 250,000 limit? Because as I look at it, it seems to have an effect of pushing estates that would otherwise be handled in a less complicated matter. They get pushed into the more complicated process precisely because of the house prices that have gone way over the 250,000.
Can SARS perhaps answer that?
Siam, I think it's a question for the master because the 250,000 rand is determined by the minister. The amount used to be 125,000 rand before 24 November 2014. And as of 24 November 2014, the amount has been adjusted to 250,000. So there was a revision of the amount in 2014 from 125 to 250, and that is an amount that is determined by the minister.
One last question.
Yes, go ahead.
What happens when the deceased has children and one of the children is deceased, but they have successors who are the grandchildren of the deceased in this case, and they are minors, and at the time of the death, or during the dissolution of the estate, they are not included as beneficiaries. How does that go?
The master maybe want to answer that, or any one of the lawyers?
I'm not sure Ms. Roberts should also come in if she wants, but I also think it's a question that we at the masters also sitting with a lot where people are not disclosing all the children or grandchildren of the deceased. But in the instance where I see from the message, it says he has 5 children and 1 child has passed away and there's grandchildren. Normally, if there's no will, the next of kin affidavit should be fully completed, reflecting all the children as well as the grandchildren where children has passed away. So we will request a next of kin affidavit of the deceased as well as of each child that is predeceased the deceased for that grandchildren to be considered. And if it is a case where the grandchildren are not reflected, we are then also dependent on those that knows about the situation to come and inform us, to take it up with the nominated person to ask why has this children not been included in the next of kin affidavit and be considered when the estate was distributed.
There's another question. If the couples were not married but were living together as husband and wife for more than 5 years, upon one of the partners' deaths, can the surviving partner apply to be recognized and administer the estate of the deceased. I don't know if the master wants to answer that, Penny or Simone, but I think it's also important to note that the Women's Legal Center supported the challenge to the constitutionality of the Interstate Succession Act on the basis that it's unfairly discriminated against women in the opposite sex or heterosexual partnerships. And the court applied the intersectional lens that we provide and examine whether indeed the client, indeed Jane Buania versus the Master of the High Court, similarly situated to her being unfairly discriminated against based on her gender and marital status. So based on this particular case, the master is now required to put in processes to allow for the situation Luanda has been speaking about. I'm not clear whether or not that has been done. The Buania matter was handed down in December last year, and it was handed down by acting judge Penny Magona, and the act made provision for surviving spouse partner to claim from the estate of the deceased partner, and those benefits are now extended. So yes, you can, but what the process is, the master will have to explain. Thank you.
Thank you. Yes, we are aware about the constitutional court case of Banyan versus the Master of the High Court in Cape Town. And in terms of that judgment, the Apex Court did say that Cabinet actually must give effect to that legislation to come through, which means we're talking about the amendment of the Interstate Succession Act with regards to a definition of a surviving spouse. If I remember the court case correctly, it also dealt with the amendment to the Maintenance of the Surviving Spouses Act.
Yes.
So yeah, so that is a legislative process that needs to unfold. You must remember that laws are actually passed in Parliament. We can only implement what has been already passed in Parliament by the signed as law by our state president, just to state the current status. Thank you.
Thank you. I'm going to, are there any other questions?
So Richard, we have a hand from Kensani Ringani.
Yes.
Kensani, yes. You can go ahead. Kensani Ringani, the floor is yours.
Oops. Gangi. Hello.
Yeah, we can hear you. You can go ahead.
It seems she's experiencing challenges, Chair. I would advise that we move on, maybe on the chat. I saw there's a question which came in on the chat. If you allow me to read on it, or maybe it's a comment. It says, it comes from Ronel, or good day, please can you touch a little on substitution of beneficiaries? If a beneficiary predeceases, can the descendants of the beneficiary inherit? Does the substitution apply automatically if not specifically mentioned in the deceased last will and testament? Thanks, Chair.
Shia, maybe I can volunteer for that question.
Yes, go ahead.
So Ronel, in terms of the descendant standing in for a predeceased, it applies in intestate succession, meaning it applies when there's no will. Where there is a will, And there's no provision in the will that the descendants of that predeceased child shall inherit their share, then that is not that it does not go automatically that those descendants will inherit. So in terms of a will, it will play out as the testator has stated in the will. In terms of intestate succession, it will automatically play out that the descendants of the predeceased child will inherit, because that is what the law says must happen because there's no will. But if there's a will, it will happen as stated in the will or as set out in the will by the testator. I hope that answers that question, Rina. Thank you.
Are there any other questions on the chat?
No questions on the chat at the moment,
Okay.
Chairperson.
But
And then
thank
there's
you
there's also no hands at the moment.
Okay, thank you. I'm going to hand over now. I'm going to say thank you very much to all the panelists. There is obviously a lot. I'm going to do I don't know, Penny, if you want to do the official vote of thanks. And on behalf of, I just want to say thank you again to the Department of Justice and all the stakeholders, South African women lawyers, National Association of Democratic Lawyers, the LSSA, as well as, various other stakeholders like SARS, and the different foundations that has made this possible. We will continue to be partners within this program, and just want to say thank you and continue doing all the wonderful work. Thank you very much, everyone. Good day.
Thank you, Siam. Yes, from the Office of the Chief Master, I would like to thank everyone who participated in this important campaign. It shows that we still have a lot to do, especially in educating and empowering our members of the public when it comes to disease states. You know, it's a fact that in each and every family in South Africa, one would have to, at some stage in time, engage with the Master of the High Court. So we need to be continuing in educating members of the public in that regard, and also assist with the developing of the law, because you can see in terms of customary law, there are certain changes that are coming our way. So yeah, thank you to our partners. Let's do this again next year. So by the powers vested upon me from the Office of the Chief Master, I declare the National Wills Week closed. Thank you.
Thank you, Penny, and everyone.